Hi, Feldblum, who will be our speaker today.
Welcome. Thank you so much for inviting me to speak today and to hopefully, together with Shelley Wright, at this final plenary for the Out and Equal Conference. So I want to talk to you about being out and being equal and what those concepts mean under current civil rights law and what they can mean for us as LGBT people. And as you heard, I am one of 5 commissioners of the Equal Employment Opportunity Commission, which is the agency charged with enforcing employment civil rights laws in this country. So we are at an incredibly interesting moment in time. It is a moment in time in which, for many people in many localities, it is not a big deal to be out. We have our families and our children. We are respected in our communities and our workplaces. That's a new thing in the history of the modern world. And yet, at the same time, it is incredibly difficult for so many people in so many localities to simply be out about who they are. And as our country has gotten a glimpse of over the past few weeks, sometimes it is so difficult that you just step out of life. We live with the duality of this situation all the time. How do we acknowledge the advances we have made without becoming complacent or jaded? How do we raise the floor for everyone so that no matter where you live in this country, no matter what job you hold or what dream you aspire to, no matter what age you are able to be out and equal in this country? Well, law is only one part of this story. But as someone who has been a civil rights lawyer for 25 years, that's the part of the story I want to talk to you about today. So let's start with current civil rights law, and specifically the law that prohibits employment discrimination on the basis of religion. Imagine this. It's March 2008, and an 18-year-old woman shows up at an Abercrombie kids store at a mall in California and applies for a job stocking merchandise. She's a Muslim, so she shows up at the interview with the hijab, a headscarf. And by the way, she's very into fashion. In a quote she gave to the EEOC investigator, she explained she's very into skinny jeans and she imports her headscarves to match her outfits. Thank you very much. Well, the interviewer asks her if she's Muslim. She says yes. The Muslim interviewer asks her if, because she's a Muslim, she's required to wear the headscarf, and she says yes. And the manager marks "not Abercrombie look" on the interview form. Now, Abercrombie & Fitch does have a look policy, which is an internal dress code that includes a prohibition against head coverings. And they treat everyone the same. No one can wear a head covering. So the woman doesn't get a job. She shows up at an office of the EEOC because that's what my agency does. We investigate cases in which people feel that they have been discriminated against in employment. We have investigators who decide if they think discrimination occurred, and we have lawyers who sue on behalf of people if the agency decides their rights were violated under the law. I like to think of us as the agency that makes the civil rights words on paper have real meaning in people's lives. So that's what happened in this case. The EEOC filed suit in court, arguing that Abercrombie needed to make an exception to its look policy in order to accommodate this young woman's religious beliefs. Now, litigation is never the best way to undo a hurt. It is long, it is drawn out, no one feels good about it. I mean, this woman was crushed in a way that no victory in court is going to undo. But bringing public cases can be very important in terms of educating employers and employees about what is okay and not okay under the law. So let's all think collectively here for a moment about what was not okay here, right? Remember, this no head covering policy applied equally to everyone. Why should a civil rights law force an employer to change how it does business just to accommodate a few people that don't match the norm? I believe it is because our civil rights laws reflect a deep and rich view of equality. Often, equality is achieved by treating everyone the same. But equality is not just about treating everyone the same, because we are not all the same to begin with. Rather, equality also means treating others as equals, with equal dignity and respect. And that means treating them in a way that fully acknowledges the integrity and fullness of who they are. This is a vision of equality that is not just about tolerating difference. It is about embracing difference. It means not just providing employment protection to someone who happens to say, "I am a Muslim," but also ensuring that a person can live as a Muslim in the totality of what that means to that person in terms of religious practice. Now, there is a legal limit to an employer's obligation to make a reasonable accommodation to a person's religious practice. The standard can impose an undue hardship on the employer. But there is at least an obligation on the employer to engage with the full totality of that person. Now, in many cases, the characteristic protected by our civil rights law is readily apparent. Someone may be able to look at you and see that you are a woman, or you are African American, or, by God, honey, you are over 40 years of age. There is nothing you need to do or say in addition. And sometimes a protected characteristic under the law is apparent because a person has made an affirmative choice not to hide that fact. For example, you can choose not to change your name from Hi Rachel Feldblum, and most people will probably assume you are Jewish. You can choose not to remove your hijab, your headscarf, before you go for a job interview, and that will tip people off that you are Muslim. In these situations, what our civil rights laws do is protect us from discrimination based on those characteristics. And the protection lies in the fact that the characteristic cannot be held against us if it has no relevance.